Paul Atkins, the SEC chair, quoted his old SEC boss, Richard Breeden, quote, "If you steal from investors, we'll leave you naked, homeless, and without wheels." We're told that the SEC ensures that every cent is accounted for to protect, quote, the little guy. But in the $14 million Veritaseum case, the SEC just admitted they haven't followed their own court-ordered accounting rules for years. Document 157 is a total damage control filing. Today we're exposing how they got caught, again, the missing $4.4 million in business expenses, and the fraud on the court motion that could tear this whole judgment apart. Document 157, busted. On December 9th, 2025, a judge ordered the SEC to produce every quarterly accounting report. The SEC's response? Document 157. They admitted they actually don't have them, and they need until January 2026 to, get this, create them. So if the money was being handled correctly, why does the SEC need to reconstruct balances from bank records 5 years after the fact? Now, this isn't just about missing reports. It's about missing pages in the documents they actually did provide. In the SEC's Consolidated Final Accounting Report, or the CFAR, pages are literally skipped. Exhibit B ends on page 5, but Exhibit C starts on page 8. So where are pages 6 and 7? And the SEC's own declarant, Mr. Sanchez, couldn't account for these missing pages because they came from a different corporation entirely, and violating the final judgment. In 2019, the final judgment was clear. The distribution agent must file quarterly status reports that include detailed accounting information. But for years, the reports the SEC filed were empty shells. They contained zero accounting details, violating a court order to provide transparency to the victims they claim to represent. This is why the judge lost patience and compelled them to act. The conflict of interest here isn't just a rumor, it's visualized in the historical record. Richard Breeden is the 24th chairman of the SEC, and the architect of the very legislative programs that created these oversight structures. But his firm, RCB Fund Services, is the one facilitating the Veritaseum Fair Fund, or the VFF. Now, while Atkins talks about protecting investors, VFF documents allegedly show legal and admin fees that defy logic, at one point indicating charges as much as $9,600 an hour to manage just 103 paid claimants. Under the Supreme Court's Liu ruling, the SEC can only seize, quote, net profits after deducting legitimate business expenses. But the SEC's proposed final accounting ignores nearly $4.4 million in documented software development and operational costs, expenses the SEC's own accountants acknowledged in 2019. Now, by ignoring these, it seems they could have inflated the theft narrative to create a $3 million windfall for the U.S. Treasury. Now, here's the real kicker on professional conduct. When SEC counsel Allison Moon replaced Catherine Pappas, Middleton's lawyer, Jason Siebert, reached out in good faith. He explicitly offered the SEC extra time to get caught up and to prepare their filings correctly. Moon ignored the offer and pushed forward with what Siebert calls material misstatements to the court. And now that the judge has ordered actual proof, Moon is the one that is begging for an extension until January 23rd, 2026, to get this, quote, build records that should have been public for years. And now Siebert points out the irony. They refused professional courtesy, and now they're scrambling because they were caught unprepared. This isn't just a paperwork error. Reggie Middleton's team has moved to vacate the entire 2019 judgment for fraud upon the court. They argue that the SEC got an asset freeze by telling the judge that Reggie Middleton was dissipating funds through a personal Kraken account. But new FOIA records from July 2025 prove that the SEC possessed documents as early as May 2018, showing that the account belonged to Veritaseum LLC, a business account, not a personal one. It looks like they could have known the truth for over a year, but still used the personal account narrative to cripple Reggie's defense. And even though Reggie neither admitted or denied the now proven false allegations against him, this asset freeze basically denied Reggie a defense and forced him into a consent judgment. With the SEC now admitting they failed to maintain court-ordered financial oversight, the foundation of the SEC's entire case is now under threat, and the evidence is on the record. And just to recap, the SEC just admitted they now have to build quarterly accountings they should have had since 2019. This is a material admission of non-compliance. If you want to see if the cops get held to the same standards as the robbers, follow me to find out what happens on January 23rd, 2026. And this isn't just one man fighting a regulator, it's a community-backed mission. The VERI Community, the SEC calls the Defrauded, actually pooled their own funds to file a supplementary amicus brief that introduced the smoking flash drive into evidence. And if you want to dive deeper into the FOIA records that prove the SEC knew the status of Reggie Middleton's account long before the asset freeze, check out this video here. And of course, as always, thank you for the support, and I'll see you guys next time.